So today we're going to start off with an important distinction. So we're going to look at Yick v. Hopkins in 1886. But the distinction that this case makes, and something that you'll see going forward in the future cases that we cover, is the difference between de jure and de facto discrimination. Now, both de jure and de facto are both Latin terms. De jure means in the law, while de facto means in fact, and this differentiation focuses on two different types of laws, though the intent may be the same. De jure discrimination is a law which legally determines that certain classes of individuals are going to be treated differently than others. A de facto law is a law that's facially non-discriminatory, but when it is actually applied, is applied in a discriminatory fashion. So de jure discrimination is much easier to identify, much easier to demonstrate, because the purpose of the law as written is to discriminate. De facto discrimination is more difficult to identify, though sometimes when it's as overt as is the case in Yick it's pretty easy for the court to see. But we'll deal with this idea of de jure and de facto discrimination throughout the rest of this section on racial discrimination. This is really the starting point for that idea, and you'll see it come up again and again in future cases. So the background for this case is that San Francisco, the city of San Francisco, passed a statute which required individuals to obtain a permit from the city in order to operate a laundromat. So the way that this actually functioned is on its face. Facially, this law was non-discriminatory. However, in the administration of the law, there was some significant discrimination that took place. And it was fairly easy to identify because every applicant who was of Chinese descent who applied was denied a permit, while only one individual who was a non-Chinese applicant was denied a permit. So there was systematic discrimination taking place. Yick the individual in this case, is one of those individuals, one of those Chinese individuals who applied and was denied a permit and was ultimately convicted of operating a laundry without a permit. So the issue in this case is, does a law that is not facially discriminatory but is applied in a discriminatory way violate the 14th Amendment Equal Protection Clause? And the Supreme Court here answers that yes, absolutely, that does violate the 14th Amendment Equal Protection Clause. The Supreme Court held that the law was administered in a discriminatory fashion, and thus, while the law wasn't written in a discriminatory way, the actual administration of that law is a violation of the 14th Amendment. If the city board, which grants permits, means to exclude an entire class of people from being granted those permits, whatever the intent of the law doesn't matter, but the way that which applies is what's important. Thus, even though the law was not facially discriminatory, think back to the Strouder case we did last class, even though it wasn't facially discriminatory in blanketly making two different rule sets for individuals in this case who were Chinese versus individuals whom were white, the actions that San Francisco undertook were a violation of the Equal Protection Clause. This case should stand out for obvious reasons. Through this time period in the late 1800s, the Supreme Court was really attempting to hinder laws which attempted to rid the US of discrimination. And it oftentimes held that blatantly discriminatory laws, infamous sort of Jim Crow types of laws, were not unconstitutional. The main decision here obviously being Plessy versus Ferguson, and that separate but equal accommodations don't violate the 14th Amendment. So despite the fact that the Civil War amendments appeared pretty broad on their face as written, they're quite extensive, and we'll see that the evolution of how they're interpreted over time largely changes. The Supreme Court in this late 1800s period really neutered the effect and reach of these Civil War amendments. So first we have the Slaughterhouse cases in 1873, where the 14th Amendment was limited and defined very narrowly to the issue of discrimination against African Americans and former slaves. Then we have the civil rights cases in 1883, in which the 14th Amendment was limited solely to state action, so that Congress couldn't reach private discrimination even if it was in public accommodations. And then in Plessy versus Ferguson, we have outright segregation in the separate but equal ruling in Plessy that is ultimately given the stamp of approval by the United States Supreme Court. So this Yick-Wo decision sort of should stand out as an anomaly there. The Strouder decision less so, because the Strouder decision sort of follows this vein. It did apply exclusively to African Americans and freed slaves. It did treat them differently, and it was state action. So that case, the Strouder case, fits neatly within those confines of the Slaughterhouse cases, the civil rights cases, and Plessy. But Yick-Wo v. Hopkins stands outside of it as something different. And I think probably one of the real reasons for this is that we were dealing with not freed slaves. We were dealing with a class of people who were not, at least at the point in 1886, did not have a long history of discrimination within the United States. Though, of course, jump forward 10 years and that history gets much longer. So this case is a notable anomaly. It uses the 14th Amendment to protect a class of citizens, which as far back as in the Slaughterhouse cases, the Supreme Court said it didn't apply to. Remember, the Slaughterhouse cases says that discrimination under the 14th Amendment only applies to African Americans and freed slaves, so it is applied elsewhere in this case. And also this case reads into the actual administration of law, as opposed to facially what the law says, and makes this juxtaposition between de jure and de facto, which becomes important later on, especially in the school desegregation area, which we are about ready to move into, where local school districts began to get fairly creative in the ways in which they attempted to continue segregation, but do so in a fashion that was not facially discriminatory, but was discriminatory in actual practice.